We're diving deep today into one of the most, well, critical battlegrounds in modern employment, the Australian workplace dispute.
And we're not just talking about minor HR issues here.
No, not at all. We are talking about really high-stakes conflicts, things ranging from allegations of serious misconduct right through to employees saying they were forced out because of a toxic workplace.
It's a complex landscape.
It is. And to guide us, we've got a pretty unique stack of source material. We have extensive details on the work of the Australian workplace discrimination representatives. These are specialists, not lawyers, who help employees navigate these really tricky situations.
And crucially, we also have summaries of two very recent, very high-profile cases from the Fair Work Commission. That's Australia's Industrial Relations Tribunal.
Right. And both of these cases put the gig economy, specifically the big platforms, under intense scrutiny.
So our mission today is really to analyze the protections that are offered to Australian employees under, the Fair Work Act and equal opportunity laws. We're going to zero in on how the FWC, the Fair Work Commission, handles claims of unfair deactivation in the gig economy.
And this isn't just about who won or lost.
No, not at all. It's about the standards of evidence, what they call the evidentiary onus, and the absolute necessity of procedural fairness that these platforms have to meet.
And what really stands out to me in these cases is just how thin the margin is between an allegation and actual proof. We're looking at judgments that hinge on whether seeing a driver make some physical movements is enough to prove sexual misconduct.
Or how the tribunal looks at historical complaints, ones that were closed years ago.
It's fascinating. Okay, let's unpack this. When you look at the full scope of workplace issues in Australia, it is just immense. The workplace representatives we're looking at, they offer support across almost every major type of conflict you can imagine.
Right, everything from classic unfair dismissal, so being terminated without a valid reason, all the way to these really complex general protection disputes.
And what are those exactly?
That's where an employer takes what's called adverse action against an employee simply for exercising a basic workplace right.
It's the really sensitive stuff they handle that stands out, too. Constructive dismissal, which is where a workplace becomes so toxic an employee feels they have no choice but to resign.
And of course, the highly charged cases involving sexual harassment, workplace bullying, things like that. These specialists really operate in that complex space of mediation and negotiation, which is a bit different from a traditional courtroom.
And that focus on them being specialists is key, isn't it? They're very clear. They are not lawyers. They don't give legal advice. Why do you think that non-lawyer model is thriving so much?
I think it really boils down to efficiency and specialization. These workplace relations specialists, they're just deeply fluent in the specific way the Fair Work Commission operates.
Which is often less formal than a court.
Exactly. It can be faster, often less expensive, and they're focused purely on getting justice and closure under the Fair Work Act. I mean, the numbers speak for themselves. They've supported over 16,000 clients in 30 years.
Wow.
So clearly, it's an approach that a lot of employees prefer.
And the sheer variety of issues they cover is incredible. They've handled everything from a $37 million fraud investigation involving an HR manager to the legal analysis for an Anglican priest's unfair dismissal claim.
That one's fascinating. It had to weigh the Fair Work Act against this unique spiritual office defense. It just shows you that workplace rights are constantly being tested everywhere.
From the executive suite to the church pulpit.
But nowhere is that fragmentation, that testing of rights, felt more than in the gig economy.
Because the traditional idea of an employee just doesn't quite fit.
It doesn't. But being terminated or deactivated still carries a huge consequence. And this brings us to the specific rules designed to protect these workers.
You're talking about the Digital Labor Platform Deactivation Code.
Exactly. It's central to both of the cases we're looking at. This code is relatively new, and the FWC brought it in specifically to inject some procedural fairness into what was, the unilateral power of these massive digital platforms.
So it's a rule book.
It's a rule book. It mandates that drivers, even though they're technically contractors, have to be given basic rights, like being told exactly what they're accused of and being given a chance to respond before their livelihood is just switched off.
So if a platform fails to follow the mandatory steps in that code, they're already on the back foot, regardless of the complaint itself.
Precisely. A failure to follow procedure is a breach of the code, and that alone can make the deactivation unfair, which takes us straight into our first case.
This is Shahid Mansour v. Razier Pacific.
That's right. Mr. Mansour was an Uber driver, and he successfully challenged his unfair deactivation.
And the allegation here was incredibly serious. Sexual misconduct. He was deactivated after a passenger claimed he was masturbating while driving.
I mean, if that's proven, it's the very definition of serious misconduct.
Of course. But when you look at the details, the evidence was, well, it was entirely circumstantial. The passenger was in the back seat. She admitted she did not actually see him touch his genitals.
So her claims were based on what she saw.
Exactly. Physical movements, heavy breathing, and him reaching for tissues from the glove box. That was the evidence.
And Mr. Mansour's defense offered a really practical denial. He said the physical movements were just him adjusting his seatbelt because, as he put it, he has a big tummy.
Right.
Or just touching his hair and beard during a shift that could last up to 12 hours. He was basically saying the platform had no idea about the physical reality of driving for half a day straight.
It's almost absurd, isn't it? The idea that your entire livelihood hangs on explaining why you were breathing heavily or why you keep tissues in your car.
If the stakes weren't so high, yes. But Uber tried to bolster the claim by bringing up his history. He had 2 prior sexual misconduct complaints from 2018.
Okay, that sounds more serious.
It does, but those complaints had been investigated at the time. They only resulted in temporary blocks or warnings, and they were officially closed years ago.
So how did the Fair Work Commission rule on the burden of proof? I mean, surely the bar for proving sexual misconduct is incredibly high.
It is. The FWC found that Razor Pacific, that's Uber's entity, bore the evidentiary onus. In Australian labor law, if you're alleging serious misconduct to justify instant termination, you can't just rely on suspicion.
You need proof.
You need proof. And the FWC noted Uber brought no direct evidence from the passenger herself. All they had was their own internal report of her complaint.
Which is legally considered hearsay.
It is. Hearsay just doesn't have the reliability you need to prove a serious act like sexual harassment.
So Uber failed on the substance, the evidence, but they also failed on the procedure, right?
Yes, and this is where that deactivation code became fatal for them. The FWC found that Uber's deactivation notice didn't specify the precise nature of the alleged misconduct. They were vague.
Which meant he couldn't defend himself properly.
Exactly. So because they failed to meet those mandatory requirements of the code, they had a procedural failure on top of the evidentiary one.
I get that procedure matters, but where passenger safety is alleged, shouldn't the FWC lean towards caution? I mean, doesn't focusing on a deactivation notice feel like prioritizing paperwork over public safety?
That is the delicate balance they have to strike. But the law requires a foundation of due process before termination. If the FWC just accepted unproven allegations and ignored procedural failures, the code would be totally meaningless.
So they're saying the safety concern wasn't proven in the first place.
Correct. Since the sexual harassment was not proven, the claimed safety risk was unfounded, so the outcome was pretty definitive. Uber was ordered to reinstate Mr. Mansour and pay him over $6,000 for lost earnings.
That sets a really strong precedent. Let's move to the second case, Anwar Karim Al-Hussein, which raises very similar questions.
It does. It's about historical complaints and vague communication.
Mr. Al-Hussein was another Uber driver, but with a huge record over 20,000 trips.
Yeah.
He was deactivated in 2025 after a complaint of non-consensual kissing, and he also won his claim.
And here, Uber's case relied even more heavily on trying to establish a pattern of historical misconduct. They cited reports stretching back almost a decade.
Like what?
Well, a 2016 report where he allegedly asked a passenger to go to an apartment with him, though the passenger herself later admitted she could be mistaken.
Okay, so that's already weak.
Very. Then a 2018 report for trying to hit on a passenger, and then a 2019 incident.
That one sounds more troubling. Allegedly asking for a kiss and taking a big tip from a passenger described as inebriated.
It does sound troubling, but here's the critical part. That 2019 report only led to a formal warning at the time. Uber's whole strategy was to bundle these old, vague, or inconclusive reports together to justify the 2025 deactivation.
And in the 2025 case itself, Mr. Al-Hussein denied the conduct and, just like the first case, focused on lack of due process.
And this is where the procedural failures were almost a mirror image of the Mansour case. Razor Pacific claimed he hadn't asked for a discussion about it.
But he had.
He had. The FWC found he'd made 3 separate requests for a discussion, which the company just ignored. Another clear breach of the deactivation code.
And they were vague again with the allegation.
Incredibly vague. The FWC called it the vaguest of terms. Instead of saying he was accused of hugging and kissing, they just used general language like unwanted sexual contact.
which again makes it impossible to properly defend yourself.
Exactly. It's a denial of procedural fairness.
Okay, so the FWC seems to have completely rejected this strategy of using old reports. Was this a major legal loss for the platform's whole HR approach, or just a procedural slip-up?
Oh, it was a substantial rejection of their strategy.
Yeah.
The commission found it was a stretch to even call the 2016 and 2018 allegations sexual harassment. But more importantly, they ruled that these historical matters were not of sufficient gravity to justify the 2025 deactivation, especially since Uber itself had deemed them minor enough years ago to let him keep driving.
Right, you can't have it both ways.
You can't. You can't retroactively weaponize what they call stale complaints to create a valid reason for termination years later, especially if you took no serious action back then.
So the FWC looked at the 2025 claim, found it unproven, and then said the whole historical pattern was too weak, too old, and just not serious enough to stand on its own.
Exactly. For the 2025 allegation, the FWC said the evidence was characterized by inexact proofs, indefinite testimony, or indirect inferences. That phrasing is really significant.
Why is that?
It reiterates that the burden of proof for serious misconduct is much higher than just a balance of probabilities. It demands a level of clarity and certainty that Uber's internal investigation just didn't provide.
And the result was that he was reinstated immediately. The FWC noted he was claiming losses of nearly $2,000 a week. That figure alone really underscores the financial devastation these instant deactivations cause.
It really does. And if we synthesize what these two cases tell you, 3 takeaways really stand out.
Okay, let's hear them.
First, the absolute centrality of the digital labor platform deactivation code. Fair process is paramount, even with serious allegations. If you fail to specify the allegations or offer a discussion, the FWC will not overlook it. It's a mandatory shield for the worker.
Okay, so process is number 1. What's number 2?
The clear definition of the evidence standard. Platforms just cannot rely on hearsay, vague passenger claims, or circumstantial details like physical movements to meet the burden of proof for serious misconduct.
They need cold, hard facts.
They need direct, substantive proof that justifies what is, a career-ending decision.
And the third takeaway.
The dismissal of stale complaints. Historical matters that were investigated and closed years ago generally can't be resurrected to justify a termination now. If the platform decided back in 2018 that the conduct wasn't serious enough to fire someone, they've basically forfeited the right to use it for that purpose in 2025.
And this whole conversation brings us right back to the role of specialists. These are complex, high-stakes proceedings.
Absolutely.
An employee who suddenly has their income switched off is under immense pressure. They're not going to have the expertise to spot these precise procedural and evidentiary gaps.
No, and that's where the representatives come in. They focus on meticulously documenting everything and building a strategy to leverage these legal requirements to get compensation or reinstatement.
These deep dives really do highlight the delicate, critical balance the Fair Work Commission has to strike. On one side, you have public safety and the seriousness of allegations like sexual harassment.
A huge responsibility.
But on the other, they have to uphold procedural fairness. They have to ensure that these workers, whose entire income can be severed instantly, aren't deactivated based on evidence that's just vague, unproven, or inexact.
And that leads to our final provocative thought for you to consider. In an age where these digital platforms hold such immense unilateral power over a person's livelihood, how far should the burden of proof really extend to protect workers from deactivation based on complaints that are vague, unproven, or years old?
And what responsibility do these huge global platforms have to make sure their internal investigation processes actually meet the high standards required by national fair work laws, like Australia's?